Hello, I am attorney Masa Sam Foray, founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to talk to you about all things related to immigration. So today's question is, what is the new public charge rule? And first of all, let me start off by saying that there's been a lot of coverage in the media in recent months under this presidential administration about changes to the public charge rule. The public charge rule is not necessarily new. It's been around for years. It's always been used to assess whether or not an immigrant is going to be likely to go on, public benefits or become a burden to the United States government by way of receiving public benefits. The biggest change that we've seen in recent months to the public charge rule is that it actually clearly now defines what a public charge is. And it gives specific parameters, specific examples, specific factors that consular officers and USCIS officers are supposed to use in order to determine whether or not somebody is likely to become a public charge. And the reason why it's garnered so much media attention is because of the disparate impact on lower income individuals and people coming from lower socioeconomic statuses. And that disparate income for many people who are watching this debate really is a human rights issue. And so we'll see what happens in future administrations. We'll see whether or not these changes made under the current administration are going to stand. But for right now, since they are the law of the land, in this video, we're going to talk a little bit about some of the factors and the changes to the public charge rule and how that might affect your immigration status and your immigration applications. So a public charge is now specifically defined as an individual who is likely to receive public benefits for 12 out of an aggregate of 36 months. So it's defined as an individual who is likely to be on welfare or public aid or receive public assistance for 1 out of an aggregate of 4 years. That specifically means that, again, one's socioeconomic status, one's level of education, one's employment status is going to definitely trigger this public charge, these public charge denials. So with regards to the factors that the public charge rule considers, and with regards to some of the factors that you need to address in your own life as you go forward on trying to submit your applications for adjustment of status, and certainly trying to submit your applications for any type of visa or for citizenship. Some of the factors are going to be your age. Obviously, the older one is, with the lower the level of education, the more likely it is that you will need assistance. Young people who are coming here for college, young people who are coming here therefore on F1 student visas, they're going to be more likely, based upon these factors, to be viewed as people who have a brighter future ahead of them and less likely to go on public assistance. Another factor that they're going to be considering and determining who is likely to become a public charge would be your health. And so this, again, when we talk about disparate impacts on particular segments of the population, when we start talking about health, people who have demonstrated mental illness and who have received, treatment for mental illness, they might be penalized for that. Because if you have mental health records of a serious ongoing or chronic mental health illness in your own country, and then you want to immigrate to the United States, well, then that might send up a red flag and trigger these public charge issues, because just by virtue of having an ongoing chronic illness, let alone a mental health illness, that means that you're going to have to avail yourself of, health insurance. And if you can't afford private health insurance, then what? Public aid. Another factor is going to be your employment history. Again, especially when you are submitting applications, for instance, for even non-immigrant visas like a B2 visa, but certainly when you're submitting applications to come here as an immigrant and they know that you will be in the United States for the long term, looking at employment history is going to be something that's going to affect you under these under the new public charge modifications. Because if you have had, employment that's not necessarily viewed as extremely desirable, if you've had employment that's not viewed as upwardly mobile, people who are working class in their own countries are going to be more hard pressed to be able to get visas to come to the United States, because if you're working class in your own country, then the likelihood of you being able to become middle class or upper class is going to be minimal. And of course, generally speaking, who does the public perceive as those most likely to be on public aid? Those are people in the working class or lower. And so your employment history is going to definitely play a big part as you go forward on future immigration applications. In addition to that, they're now looking much more closely at assets. This ties in with the last, point. Your employment history, your earning history, your earning potential, and then the assets that you have amassed or not amassed in your country. So again, to bear this out, this has always been true for, let's say, B2 tourism visas, right? Because in that sort of visa, you are telling the government that not only can you support yourself when you come to the United States, but you can support yourself for a vacation to the United States, and that you have no intention on being here for the long term. So in that sense, assets and employment history have always played a big part. But what about family visas? When we talk about family-based visas, and we're talking about somebody who's coming here, as the spouse of a U.S. citizen, or as the spouse of a green card holder, or the parent of a green card holder, this public charge rule is going to really affect the rate of denials, because many people who bring their family members here, they bring them here regardless of their earning potential. They bring them here regardless of their educational history or regardless of their assets. They're trying to emigrate their family for the purpose of family reunification. But I think that we're going to see a big increase in the rate of denials for family-based visas. And so, at this point, what we do know is that there have been serious changes. There are any number of different scholarly articles, news articles, and certainly even information on USCIS's website about the changes to the public charge rule. So just make sure that you read up on them, whether you are the seeker of a visa or whether you are the sponsor of a visa, to know how it would affect you potentially. And if you have any questions about how this law is applicable to your specific case, definitely reach out to a trusted immigration attorney. And I hope that this has been very helpful for you.